Hey, look, we've got an email question. Let's go to that first email question. If someone gets in a wreck with a drunk driver, do you have to wait for their criminal trial to be over before seeking damages for your injuries? And that's from Brian. Brian, the short answer is typically no, you don't have to wait. There might be some considerations though that you want to take into account to wait. So for instance, we've had a couple of cases here recently. We've got one case that's currently, well actually two cases that are going on right now where one, we had to wait for the criminal charge to get finished so we could take the person's deposition. Even in a criminal DUI case, there's a right to plead the Fifth Amendment. And so in order to get the nuts and bolts of what's going on, we needed to, you know, it's kind of a balancing act as to whether or not you're going to be able to take the defendant's deposition. Sometimes the courts will grant you 6 months. Sometimes they'll say, all right, well, we'll wait a couple more months since it looks like the DUI is going to be over. And then other times it takes a little bit longer for that so that you can evaluate the case to determine whether or not you may have what's called a dram shop case. You know, somebody that was served alcohol who's a known alcoholic in the state of Florida. In Alabama, it's just a mere overservance that you may want to find out and get that information and get the details for it. Hank, come back here, buddy. Have to do that because Hank wants to go check on everybody. They all left the studio and he's wanting to know why everybody left. Okay. But going back to the question though, whether or not, you know, if your damages can be identified, if it's within the policy limits, and then sometimes you may want to ask for a personal contribution. You know, you got a lot of different factors to take into consideration, but typically you do not have to wait, but there are some considerations where you may need to wait on that. So Robert, how do you, you know, when you're, you know, defending somebody in a DUI and there's been a traffic accident that's involved with it, you know, what do you do in that situation?
Well, the first thing I do is get somebody like you involved because you've got a lot of experience in that area. But, you know, the biggest thing is we want to make sure on the insurance issue, you know, because there's going to be a lot of civil considerations that go with a criminal. But the criminal charges, depending on that, where people have been injured, it's usually a higher standard. And based on the higher standard, there's more penalties involved. You know, we have diversion programs and programs that might reduce or dismiss or lower the charge of DUI. But if someone's been injured or it's been a fatality, that's probably not going to happen.
Yeah, especially if there's a fatality. If there's a fatality involved.
You're absolutely looking at jail, different charges that are being elevated. But a first-time DUI where someone's injured, we often have scenarios where cars run off the road or the police report may show as an accident, but it really wasn't that, in that there was not an injury. No one was hurt. Maybe there's just a single car accident where they left the roadway, you know. So, you know, those can be mitigated too, depending.
Yep. So you've got mitigation factors, you got enhancement factors, you've got a lot of different things to go in there. Should somebody try to go into court and handle a DUI on their own? And when I say go in there and handle a DUI on their own, if somebody's been charged with a DUI, should they go in and try to say, you know, I've got a good excuse, you know, I've got this, I've got that. Should they do it on their own? No, absolutely not. A DUI is a very serious charge. It's a charge that can impose jail sentences. You can go and spend some time in jail. There could be a lot of monies involved. It can kill your credit score rating on credit cards. Insurance, you get put into a non-standard. They're talking about the SR-22 issue. And if you go into that, you might be there for 10 years. And in Florida, a DUI will stay in your record for 75 years. Right. It doesn't go away. It's it's one of the few charges in the criminal system that cannot be expunged. Meaning you don't get a clean slate. But in Alabama, we can. There's differences on that issue, but correct, in Florida that you cannot. And, you know, Florida is very serious about DUIs, very serious. You know, they put the onus on the person who's driving, not the person who's serving. Correct. And so a lot of personal responsibility for somebody that's been involved with a DUI, and certainly something you don't want to do.